Welcome, fellow instructors. I'm thrilled that you're with us listening to what we've got for you today. And welcome, as I said, to the ranks of being an instructor. You should have received two things from us. One is the workbook, and for this webinar, we're going to use the workbook as your reference material. That's not what we're going to be necessarily following. You also should have received a PowerPoint handout, which will take you through the course. So what's in the PowerPoint is the same as what's in the workbook, but I'm going to be honest and tell you we're taking it in a little bit of a different order than what's in your workbook. I will make sure you know where we're at. And by the way, let's start with that as one of our first instructor development hints. Try to always make sure that the students know exactly where you're at. So either your PowerPoint needs to tell them what page you're on, or you need to tell them what page you're on. Because one of the complaints we get from the students quite often is that, and you'll see it in your classrooms, when they're rifling around looking for where you're at. So kind of make sure that they kind of know. So as we get started, we're going to start with section 5, which, by the way, is on page 42 of your manual. And we're going to start with that and talk a little bit about who needs a license. As you're teaching the course, going through for the students who needs a license and who doesn't. So anyone, as we can see, who is offering real estate for sale or for lease, anyone who negotiates those contracts, anyone who supervises or attempts to collect rents for others. We're going to see on one of the future slides where we're going to talk about how if they're doing it for themselves, or an employer, they do not need a license. But if they're doing it for others and for compensation, everybody you see that's listed there needs to have a license, including those who are making referrals. So one of the strong points that can be made from this information is that someone who, for example, I have a real estate license. Someone I know knows someone who is wants to sell their home. Let's say it's my brother. So my brother calls me and says, Len, I have a friend who's going to be selling their home, and then my brother asks for a referral fee from me because he gave me the lead. I can't pay him a referral fee because my brother does not have a real estate license. So when this is part of your discussion, it shouldn't just be automatically remembering who needs a license and who doesn't. The real kind of takeaway from this is we can't pay referral fees to someone who does not have a license. Also, anyone who is attempting to solicit for real estate. So once the students get their real estate license, and if they're going to have someone, for example, door knocking for them looking for listings or trying to find buyers by making phone calls or any other kind of solicitation, they too need to have a real estate license. So anyone who is interacting with the public needs to have a license. They also have to have a real estate license to hold an open house. So again, focusing a little bit on why this is important to the students. If in fact I have a listing and I need to hold it open on Sunday, but I, the agent, can't be there, I can't have an unlicensed person holding that open house. So this is the reason for making sure everybody kind of understands who needs to have a real estate license. So who doesn't need a license? Pretty obvious. It's the people who, if they're doing it for themselves, if they're an employee of the owner, if it's an attorney under an authorized power of attorney. Don't think we need to focus as much on who doesn't need a license as we need to focus on who does need to have a license. So as we're taking them through their pre-licensing, I think one of the things we need to do, and I'll share with you just a little bit what I do more than just pre-license, is I do a lot of post-licensing. And what I find when the agents are done, when they are now licensees, and they get into the real estate business, they're having trouble understanding why anything they learned in pre-licensing class even has anything to do with what they're doing in the real estate business. So I think it's up to us as the instructors to kind of be the bridge there. This is what's in the license law. This is what you have to learn to pass the test. but this is also how you use it when you have your real estate license. So they don't feel that they have wasted hours of their lives just getting the license. So this isn't going to be as big a deal because they are going to have a license. So you're going to run through it, but you're going to focus more on the who needs a license and how all of that plays out for them. There's 3 different categories of licensure. One is broker, and then managing broker, and then the residential leasing agent. The leasing agent license status is separate and apart from the other 2. We do have many leasing agents out there, but vast majority of people getting into the business are getting in as a broker. So you have to be a broker for 2 years before you can become a managing broker. So what most of us are going to be doing is we're going to be teaching the broker classes. Teaching the managing broker classes is just different, a little bit different curriculum than the brokers classes. So who administers all of this? Who is the one that what group, if you will, is going to make sure that all of this is done correctly? It's IDFPR, the Illinois Department of Financial and Professional Regulation. IDFPR, the Illinois Department of Financial and Professional Regulation. And this is what they do. They issue and renew all of the licenses. They authorize the exams. They're the ones that create the exams. They prepare all of the forms and all of the applications for licensure. They also conduct office examinations. They come into our real estate offices and do what we like to call friendly audits to make sure that the offices are being run correctly. They are going to investigate any complaints or allegations of violations. So when someone files a complaint, either a member of the public or another licensee against one of us as licensees, they do the investigation. They will then conduct the enforcement hearings. If after the investigation it looks like there was a violation, then it will go to prosecutions, and from there they can impose discipline on our licenses. And that discipline can range, get quite extensive. But this is what happens, and this is why they end up disciplining our licenses. This is basically in the license law, section 15-20. We refer to it as the bad acts section of the license law. And this is where it lists the kinds of things that we can have our licenses disciplined for. Cheating on the exam. So right away, if they're going to cheat on their real estate exam, they're not going to get a real estate license. That's pretty much self-explanatory. Failing to properly maintain escrow accounts. We will talk about the escrow accounts in a little while. It is one of the top reasons why our licensees end up either losing their licenses or being fined, or worse, sometimes ending up in jail because they've messed with other people's money. So we'll focus on that a little bit. And I know there's a lot of times people will say, well, why are we teaching the brokers about escrow? They don't do it. It's the managing brokers who do it. But the handling of the escrow funds directly affects the consumer, and it's the brokers that are directly working with the consumer. So we'll talk a little bit more about escrow, but it really is one of the top issues. Improper guaranteed sales program. I'm not even going to be touching on the guaranteed sales program. I think what we need to remember about guaranteed sales program is that if you're going to be doing one, you have to follow it specifically the way it's in the license law. But in all honesty, we don't have a lot of people doing guaranteed sales programs right now. So one of the things we need to look at when we're teaching all of this is, yes, we have to have them pass the exam, but how much time are we going to spend on something that's not really being done right now? And guaranteed sales are not. Practicing without a license, yes, IDFPR does have the ability to fine and prosecute, if you will, someone who is doing licensed activity and does not have a real estate license. Again, not so much a worry for what we're doing because we're teaching pre-licensing, but certainly important in the big scheme of things if there's somebody out there who is listing and selling real estate, asking for referrals, holding open houses, and doing the things I talked about before, and they do not have a license. They can be fined, just like those of us who have a license can. The one that can get us no matter what is this dishonorable, unethical, or unprofessional conduct. Conduct unbefitting, if you will, a licensed real estate agent. And there's a lot of people who say, well, wait a minute, that's a wide open category. I think it needs to be a wide open category. Do you realize how long the license law would be? How would we ever teach it if we put every single thing in there that we could do? By the way, even if we tried to put every single thing in there that we might possibly do, there's still somebody out there going to invent something we haven't heard of yet. So this is the category where if it's unprofessional, if it doesn't have to specifically say in the license law, you cannot do this. So this is why we call it the bad acts section. If we're falsely or fraudulently misrepresenting anything, ourselves, property, anything that we are doing, directly negotiating with a client of another licensee. This comes into play typically once a contract has been signed on a property and a listing agent will try to talk directly to a buyer agent, or the buyer agent, or I'm sorry, when the listing agent will try to talk directly to the buyer instead of through the buyer agent, or the buyer agent tries to talk directly to the seller without going through the listing agent. So we cannot negotiate directly with someone else's client. Blind advertising. You learned a lot about advertising in some of the other courses, in some of the other parts of all of this, but advertising without using the brokerage company name is what blind advertising refers to. Whenever I advertise as a licensee, I must advertise using my brokerage company name. I am not authorized in any way by the license law or by my brokerage company to advertise without using their name, which includes anything that's on the internet, anything that I am doing. It's supposed to be on my email signature. It's supposed to be on everything that I use, the name of the real estate company that I work for. If I have a license in another state and I am disciplined in that state, it's a violation. A violation of the Illinois Human Rights Act. It's an automatic violation of, we don't even need to have a hearing on that one. So the Illinois Human Rights Act, and we will have more on that in a little while as well, but that is where our fair housing for Illinois is. So if we are found in violation of a fair housing, if we are found with a fair housing violation under the Illinois Human Rights Act, it's an automatic suspension of our licenses. So it is not something that we even need to have another hearing on. You already violated one Illinois law. You don't have to have another hearing. Advertising property without the consent of the owner. I need to have something in writing from the owner of the property for me to advertise it. If I do not have their permission, I cannot do that. And I know that sounds, when people are just getting into the real estate business, as a, well, duh, of course I would have their permission. But really where it plays out and where we need to remind them is if I have a listing and that listing expires, and a different real estate company now has the listing, I have to stop advertising that property. I cannot have it on my website. I cannot have my sign up once that listing has expired. So really controlling the advertising in many cases after I don't have the listing anymore is the bigger issue under that particular part of this. Failing to disclose my status as a licensee in any real estate transaction I'm involved with. Also in the, unfortunately, hitting one of the top reasons why periodically, and these fluctuate, by the way. It could be a rash of a whole bunch of people didn't disclose they were licensees, and that's what we see as the violations and the disciplines. Then we don't see it for a while, and then we start to see it again. But overall, this is usually a biggie. It doesn't make any difference whether I am buying property or I am selling property. If I have a license and I am a principal in the transaction, I have to disclose that. And it is supposed to be disclosed on the sales contract. So what you might want to make sure you tell your students is that where their name shows up on the sales contract, in parens, if they just put licensee, they will have in fact disclosed everything they need to disclose. So it is a big issue sometimes for IDFPR when we do, well, anytime we don't do it, it will be a big issue. And depending on the ebb and flow, if you will, of the complaints, sometimes it's really in the top three. Representing a broker other than our sponsoring broker, as you take them through their pre-licensing, you will talk to them about how they're going to be sponsored by a managing broker. That's the person that they work for. That's the one they represent. They cannot represent any other broker. Not a biggie. It doesn't happen very often, but it's something that needs to be mentioned. And then the last one on the list is if complaints come in that any of us are habitually abusing alcohol and drugs, and I think that would fall back under the dishonorable, unethical, or unprofessional conduct. But it had to be added to the list. So there's other things, anything in the license law, and we will spend a little time in this course, obviously, talking about agency, because that would be the other big issue. So the three big issues that we tend to see, looking at the top three almost always, is the commingling or the messing around with the escrow funds, agency violations, we didn't do the agency disclosures properly or didn't represent our clients properly, and the third one is we didn't disclose that we were a licensee when we were part of the transaction. So with those three being the big ones, the rest of these are something that our new agents all need to know, could be violations of the license law. So let's talk a little bit about that earnest money or escrow. It is really kind of an interchangeable thing. When a buyer's buying a property, they are going to put up earnest money. The earnest money is what goes into the escrow accounts. The earnest money is to show the buyer's good faith. I mean, that's exactly what it's called. I am in earnest. I'm going to buy your property. It should be sufficient to keep the buyer from walking away from the seller. That's the whole idea. The seller's going to take their house off the market for the buyer. And if the buyer's only got, as I say in most of my classes, 4 cents in a chicken, for earnest money, what's to keep them from just walking away and saying to the seller, I changed my mind, I'm going away. So earnest money, we need to kind of instill in our agents from the very beginning that earnest money on the listing side, my job is to get enough earnest money so as to keep the buyer, if he's qualified, into the transaction. The earnest money must be deposited the next business day following the acceptance of the contract, unless the contract says something differently. And I don't think it's important right now to go into all of what it might say in the sales contracts. We do not have a statewide sales contract in Illinois, as all of you know. So it's really difficult when we're teaching pre-licensing to be able to get too specific about this, and you don't want to get too specific. It's not going to be on their exam, and you start teaching your sales contract in that area, you're going to have a little bit of a problem because not everybody in your class may be using that same sales contract. But typically what happens is the sales contract just says earnest money will be X. And unless it says something like, and will be tendered 2 days after acceptance, then the way the license law is written is that it should have been there with the contract and it gets deposited the next business day. Not 24 hours later, but the next business day. And I think that's an important distinction to make because those kinds of questions do show up on their exam and it confuses them sometimes. I hear even from the experienced people when I do some of the classes that they're still of the mindset it has to go in 24 hours. That's not at all what it says. It's the next business day. And it cannot be commingled with any personal accounts or any other company accounts. So if this is somebody else's money, the buyer's money, that money must go into my designated escrow account. I cannot put it in my business account. I cannot put it in my personal account, even with the right idea in my head, which is I'll put it in the escrow account later, and it has to go into escrow. So let me give you a quick example that you can give that we've seen happen. The buyer has cash. The buyer has $3,000 worth of cash. Don't ask me why buyers are running around with $3,000 worth of cash, but we've had it happen. So I now am the buyer agent. It's a Tuesday, it's a Friday. I now have $5,000, $3,000, $2,000 worth of cash. What am I going to do with it? I don't want to keep the cash, so I think, let me put it in my account and I'll transfer it over and that way it's safe. No. What we need to say to the agents is if you tell the buyer to go to a currency exchange and buy themselves a money order or something, but it's where we get cash that we think it's safer in our own accounts. It's not safer. We just violated the license law because we put somebody else's money in our account. So you can use that as an example for them if you'd like to, because for the most part, this is managing broker issue, but the agents need to understand that that earnest money will be deposited the next business day so that the buyers make sure that they've got the money in their account to cover it. Where we have had problems is the buyer agent didn't explain that to the buyer. He thought for some reason it wasn't going to get cashed until he got to the closing, and now we got checks bouncing. Now you have a voidable contract because the buyer's in default. So we want to make sure that everybody understands how that is going to be handled. One of the ways you might want to be able to do this with your students to break up the monotony of us just lecturing to them all the time is if you, for example, assigned them the chapter in the book about escrow, that you might want to do a quick escrow quiz with them when you started off the next session. So I've got an escrow quiz. I thought it might be interesting for you guys to do it as well. So you can see on your, in your handout that you have, and I've got it broken down the first 6, and then we'll look at the other ones in a moment. So why don't you take just a couple of minutes to look at what you see on the screen. You've got 6 questions there. How would you answer those escrow questions? So I'll give you just a couple of minutes to do that. So now that you've spent a couple of minutes answering those first 6, take a look at 7 through 10. That's your next slide. You can see it on your screen now if you didn't print out the handout. Take a couple of minutes, if you will, to answer those last 4 questions on the slide. So the first question we had was, license law requires all brokerage firms to have escrow accounts, and that one is false. License law does not. So the company that the agents who the prospective agents that we're teaching, they may not even hold escrow accounts. So they do not have to do it at all. And likewise, then, question number 2 that said license law determines who holds the earnest money is also false. It is the sales contract that determines who's going to hold the earnest money. So they may not even get involved with having earnest money in the companies that they work with. So it's not the license law that dictates that. Question number 3 was, in order for a contract to be enforceable, there must be earnest money, and that also is false. There has to be consideration in order to have a contract, but the consideration does not have to be earnest money. So if a buyer and a seller, I guess I would say a seller, is foolish enough to accept an offer from a buyer with no earnest money at all, it would still be a legal binding contract. So number 4, the escrowee must notify all principals in writing if a buyer fails to tender escrow monies or an escrow check bounces, and that one is true. So that's why it's so important then that our agents, as they're getting into the business, understand about the deposit of the earnest money so that they can make sure that their buyers don't put themselves in default, as I said earlier, because the minute that check doesn't clear or the buyer doesn't bring the earnest money in on as the contract calls for, he could be in default of the contract. Number 5 said, if earnest money does not get submitted according to the terms of the contract is automatically null and void. That's false. It's not automatically null and void. It is voidable, not voided. And there is a distinction there that needs to be made, that if the buyer does not bring in his earnest money, it doesn't kill the contract because it's not there. It gives the seller the ability to kill the contract because the buyer is in default. So the difference between voided and voidable is a distinction that should be made, and this is a good example of the difference between the two. Number 6 talked about which of the following is true, and this just reiterated the discussion we had just a couple of minutes ago. Earnest money must be deposited within 24 hours was A, and B was earnest money must be deposited the next business day following the execution of the contract, and that one was B, the next business day. Number 7, on a closed transaction, earnest money cannot be dispersed from escrow earlier than the day of closing unless there is a written direction of all of the principals, and that's true. So when we have earnest money, we're not supposed to be taking it out of the escrow account and doing anything with it before the transaction closes, the day of closing. If for any reason we need to take it out sooner than that, and an example of that might be if I had a buyer who wanted his earnest money in an interest-bearing account, in order for me to be able to have the interest check there for him at the closing, I would have had to have taken his money out of there before the day of the closing. Otherwise, we don't know what the interest is going to be or to be able to issue that check. So it doesn't happen very often, but when it does, we have to have permission to take the money out before the day of closing. Number 8 said if there's a dispute between parties regarding the escrow money, the escrowee must hold the deposit until all parties have agreed or the court rules on the disbursement, and that is true. We call that no, we cannot disperse the earnest money without joint written direction of the parties. So we cannot, just because one person says, give me my money back, we can't do it unless we have in that case, the buyer would be saying, give me my money back. I have to have the seller's direction to do it as well. Number 9, on a terminated contract, earnest money must be returned the next business day after receipt of the release signed by all of the parties, provided the check has cleared, and that is almost verbatim what's in the license law. So when the transaction falls apart because the buyer did a home inspection and the seller won't make the repairs the buyer wants, then the buyer says, I want my earnest money back. I cannot give him his earnest money back till the seller signs off on it. Once the seller signs off on it, provided the check is cleared, I now have to give the earnest money to the buyer the next business day after I have that release signed. So that's the process for it. And then the last question had to do with the brokerage signatures. An escrowee may require signatures of the cooperating brokers prior to releasing the earnest money, and that one is false. The brokerage companies have nothing to do with the earnest money, the return of the earnest money. So once the buyer and the seller, joint written direction of the parties, once the buyer and the seller have said this is what we want to do with the earnest money, then we just follow the directions of the clients. So in teaching the whole earnest money to them then, this is sometimes a better way to do it because you can give them examples, you can kind of show them how it works, and you can kind of test their knowledge of what is going to happen with the escrow or the earnest money. So what can IDFPR do then if we violate the bad acts list that we talked about, the escrow issues? They can refuse to issue or renew a license, and that would happen even from the very beginning. So you could go through, if you wanted to, some examples with them of why they may refuse to issue a license in the first place, and that has to do with felonies, that has to do with a lot of other things in the background of the licensee, but you've probably already covered that in your classes by the time you get to this. They can put a license on administrative suspension, they can reprimand the license, they can put it on probation, they can suspend or revoke the license, they can impose a penalty of up to $25,000 per violation, and they can also issue what's called a cease and desist order. A cease and desist order can be done even before a hearing is done if they believe the public trust has been violated. So if there is a company, for example, that's bouncing checks all over the whole state of Illinois, they can come in and do a cease and desist order for that company until they have time to investigate why there's so many problems. But that doesn't usually happen. Usually it's after a complaint is filed, after a hearing, and then the fines can be as much as $25,000. And it was the Quinlan and Tyson case. The Quinlan and Tyson case happened a long time ago, but it was the precedent here in Illinois for the courts to say that the real estate agents cannot practice law. And practicing law without a license is going to fall under the unprofessional conduct category. We can only fill in the blanks on authorized contracts, those contracts that are commonly used in the marketplace. We cannot create contracts. We cannot create any kind of documents, including addendums that go to contracts. That has to be done by the attorneys. The real estate agents can only fill in the blanks on the that have been created for us. So, and it is Quinlan and Tyson, and we still talk about Quinlan and Tyson even to this day, because it was their screw up that caused the problem. So if it wasn't them, it would have been somebody else. So it didn't make any difference. We were a little over our skis back then and doing things we probably should not have done. And the Bar Association stepped in. So that is the first section that we are going to cover. We are now going to switch to your section number 1 in your manuals, starting on page 3. And this is all about real estate concepts. So this is going to have like a little potpourri, if you will, of different things that are not only on the exam, but also important to our licensees. And one of the things that we need to instill in them and make them understand, because it's so important to the consumer, is what is this thing we call supply and demand? When I do, for example, the new agent orientation after you guys have gotten them licensed for us, they join a realtor association in most cases, and then they must go through an orientation class. I teach the orientation class for a couple of the associations up in the north part of the state. And one of the things I tell them all the time is that your whole life in the real estate business is all about supply and demand. If you do not understand how supply and demand affect the value, the pricing, and everything your clients are going to do, then you are not very useful to your clients. Because when a seller puts their house on the market, they've got to know what this is all about so they know where to price their home, and whether or not they can stretch a little because we are in a seller's market, or whether the buyer needs to come up in their price because it's a seller's market, or are we in a buyer's market? Are we in a place where the buyers are calling the shots and it's the seller that's going to end up under the bus at the end of the negotiating? So it's all about supply and demand. High demand and low supply. If we have a lot of buyers out there looking for houses and we don't have a lot of houses to sell, then the prices will go up. If we are sitting there looking at not a lot of buyers and a high supply of inventory, then that's going to bring the prices down. And the very real issue here is within a town, you can have a section of it that's a buyer's market, and at the same time you can have a section of it that is a seller's market. It depends on desirability. It depends on so many different things. But explaining to the students how supply and demand works and why it's so important. See, years and years ago, many years ago, back in the day, as they say, we had MLS books. And the buyers came to us, and if they didn't come to us, they did not know what was for sale. As you all know, as licensees, you've been doing this for a while. We don't have books anymore, and we are not the gatekeepers. The information is out there for the buyers. They do not have to come to us to find out what is for sale. Well, they have to come to us and find out what's really for sale, because some of the information on the internet's not correct, but they still don't need us for that. What do they need agents for? They need us for information. They need us to make them, the buyers and sellers, informed consumers so they can make the right decision about the largest single purchase they are ever probably going to make in their entire lives. And it's not just a purchase. When a buyer buys a house, it's going to shape their family and for years to come. So it's important that we make them as educated as we possibly can, and this is where it all begins. When they get into the real estate business, once you get them licensed for us, they will have access, hopefully, once they join the Realtor Association, to their multiple listing service. Every multiple listing service in the state has analytical data in it that's going to help them come up with this information. So it's not a matter of they got to run the data for them. We do it. It's just a matter of them understanding where to find it and how to explain it. And the factors then that go into the supply-demand issue. Supply, the labor force, the construction costs, governmental controls, and financial policies of the government all have to do with supply. It also affects sometimes the demand as well. The demographics, all of this is it goes back and forth. Really, I should have kind of mingled them all together almost, because if we have high unemployment, we don't have a lot of demand. which the labor force, we've got it on the other side. You've got to know what's going on in your communities as well. We need to make sure the agents understand that, because if there is a huge layoff of a major employer in a marketplace, is that going to affect your supply and demand? And the answer is tremendously, if you've got some of that stuff going on. What's going on at the federal government level with Fannie Mae and Freddie Mac and all of the other governmental controls that are involved? Huge issue when it comes to the availability of financing. So this is what affects supply and demand. And then the other issue is that every property that's out there is unique. No two properties are the same, even if they are even if it's a condo or a townhouse, or it's in a subdivision where the builder only built 3 different models. Everybody has made it unique to them. They have customized their homes. So it's not always going to be the same. As I said earlier, the location is the biggest issue. We joke about this all the time. You hear it, you've been hearing it for years. What's the 3 most important things when it comes to real estate? And the answer is what? Location, location, location. It's true today, just like it's always been. Where is that property located, and whether or not there's high demand for it, and whether or not any of these factors are influencing whether or not the demand is even there, or the supply is even there. So once we kind of get a picture, big picture of the supply and demand, the next issue is understanding this bundle of legal rights, if you will, that go with the ownership of real estate. We have the land, that's the earth, and it goes below just what we walk on, because we also then own what's underneath it, unless we have sold off the mineral rights or to what's under the ground. Most of the time we have not. So that means if I own a piece of land, I not only own what's under the ground, on the ground, but under, and I also own what's above it, and that's my air rights. So and the physical improvements that are made on that property are also part of the real estate. So when we talk about real estate, we are talking about not just a house sitting on a lot. We're talking about what's underneath what we see, as well as what's above it, and that's our air rights that are above it. What comes with that then is the right to possession, control of the property, and my right to what they call quiet enjoyment of my property. To the exclusion, meaning I have the right to exclude people from my property if I choose to do so, and the right to dispose of that property. Now, all of this also has to be done within any legal requirements of the municipality, the county, the township, the state. So, for example, I own the property, I control the property, but if it is zoned for residential, then I cannot build a business on it. So, and there are people who just go, nobody has the right to tell me what I do with my property. Well, yeah, and we're going to have a little discussion later on of land use and why it is important for the value of properties as well, that there be a land use regulation in a municipality, so that you don't have some of this, I'm going to build a hog confinement right next to a subdivision. So I'm not going to put a trucking facility in so that the driveway with semis running down it is right in front of the houses that were built there. So there is a reason for that. But within that, we have the right to do all of that: possession, control, enjoyment of our property. I have the right to exclude people from my property if I choose to do so, and dispose of it as I choose. So with that whole discussion, I talked about, and we need to impress upon our agents that are getting to the business as well, what is real property and the difference between fixtures and real property, because it is an issue that comes into play when they're negotiating contracts and they're selling property. Real property is the personal property attached. Light fixtures, cabinets, all of that becomes part of the real estate. So if it is attached, then it's part of the real estate. Personal property is movable. It's not affixed to the property itself. So an example, which usually every sales contract in the entire state takes care of, but it is an example. I have shelving units on the wall of my home. The brackets that the shelves sit on Technically, the brackets are fixtures. It's affixed to the wall. Technically, the shelf unit that sits on the brackets that is not affixed, just lays there, is personal property because it's not attached to the real estate. Most of the sales contracts are going to take care of that. It's going to say all shelving unit, all attached shelving and appurtenances to it and all of that. Don't worry about that. It's an example to tell them that if it is not affixed, then the seller has the right to take it. And then we have chattel. Chattel is furniture, things that don't, in your right mind, you wouldn't expect them to stay with the property, and they're not going to. So when, in fact, we are going to write contracts, however, one of the things, and when we talk about the contracts, we'll get into this a little deeper, but one of the things, and the reason we're bringing this up, is that anything my buyer wants the seller to leave, I have to put it in the sales contract. If I don't put it in the contract and it's not a fixture, it will not be staying. And likewise, any seller who wants to take a fixture with needs to exclude it in the contract or they're going to have to leave it. Example you might want to give would be a dining room chandelier that they absolutely love. Maybe they got it from their in-laws. I don't know. Well, in that case, they might want to just leave it. But maybe they got it from somebody, they really cherish it. They have to exclude that in the sales contract. Otherwise, that light fixture, because it's a fixture, has to stay. So the difference between personal property and a fixture. Trade fixtures are a little bit different. Trade fixtures happen in commercial real estate. Those are fixtures that are owned by the tenant. As long as they can be removed without damaging the property, then they go with the tenant. And those are all taken care of in the leases or in the sale of property, but mostly this is in the leasing side of it. Ovens, gas grills, kitchen equipment in restaurants. If they're renting the space, they have the right to, and it will be in the lease, they have the right to take their trade fixtures with them because it doesn't damage the property when they take it. So those are the issues with the personal property and the real estate. The next kind of concept that we want to make sure they understand is the characteristics of real estate itself. There's economic characteristics, that's the scarcity of it. There's a finite amount of land. A good example of that is how expensive waterfront property is in most communities. Hugely high I don't care if you're up North Shore on Lake Michigan, you're up in the Chain of Lakes area, up in McHenry County, come down to Lake Springfield, go down to Rend Lake, no matter where you're at, the land that's on the water, because it's scarce, there's not a lot of it, tends to be way more expensive than the land that is even across the street from the water. Improvements, any improvements that are made to the property are going to be economic benefits to the property as long as they're done correctly. What's really interesting is, unfortunately, when we're doing the pre-licensing, we don't have time to go into some of the stuff we'd really like to talk to them about, which is, are there things that a homeowner can do to their property that might have cost money but didn't add 1 ounce worth of value to their property? And we all know the answer to that is yes. The homeowners don't get it. They think everything they put into their property should make their property sell for more. Well, let's face it, some of the homeowners are just nuts. And what they did to their house does not necessarily create that much value. Permanence of the investment, absolutely. It's permanently there. And we talked about the location. Physical, it's indestructible, it's unique, it's the immobility of it, it isn't going anywhere. Those are the things that characterize why real estate, a certain parcel of real estate is going to sell for different than another parcel might sell for. There's some laws that we need to be aware of. No matter what we do, we have to remember as licensees that we and our clients have to follow all of the laws. I'm not going to get into the U.S. Constitution other than to say, yes, there's some stuff in there that we need to follow. There are federal laws. There's the Do Not Call registry that all of us as agents need to follow, that if somebody's on the Do Not Call registry, we are not going to be making phone calls to them. They need to check the Do Not Call registry before they just start making those calls. We've got email regulations. It's called the Can-Spam Act, about sending out emails to people. All it really says in there is, and I know you're all going to laugh at this because everybody always does, if I'm sending an unsolicited email, I'm not supposed to do that without having a way for you to unsubscribe from that email. Here's the problem most of us have. The minute you start unsubscribing from the emails, you seem to get more emails because now they know they got a what? A live email address. It is out of control. I don't know if anybody's going to get it back under control, but I don't think our agents should be just randomly, they can't be, randomly emailing people without having that unsubscribe on there. And then the Junk Fax Prevention Act. I don't know that I would spend a lot of time on this with the agents because we're not doing a lot of faxing anymore. As a matter of fact, a lot of us don't even have our fax machines. We're doing mostly electronic. We have regulatory agencies. We'll talk a little bit more about them as we get into this. We talk about Fannie Mae and Freddie Mac and some of the other regulatory agencies. The state constitution, obviously. Local ordinances within a municipality or a county. You could have fair housing and rental ordinances that are very unique to that area. We'll talk a little bit more about this when we get into talking about fair housing. And we'll talk about some of the municipal ordinances. But then look at the state laws. And this isn't even all of them. All of what you see here are rules, laws that we need to know about, not necessarily to pass their test, but their pre-licensing exam, but they need to know that when they get into the real estate business, this is stuff they're going to have to know about. A lot of what you see there affects rental of properties more so than it affects the sale of properties. If somebody's getting into the property management side of the real estate business, it's a huge level of knowledge they have to get for themselves so that they understand everything that's going on in the business. So yes, the laws in the real estate business are immense. And it's not just the license law that they need to be concerned about. License law is what they need to be concerned about to pass the test, but we're trying to prepare them to be real estate agents beyond just passing that test. So make sure that they are aware of that. So that was kind of the random terms that are involved in the real estate business, if you will. And now we're going to go into what's in your manuals under what's called Section 2, real estate brokerage, and a little bit about the managing broker supervision. And that's on page 10, if you are so inclined to want to follow that way. I suggest again, and I mentioned this earlier, no. Use that as your reference reading material after we're done to pass the exam. Kind of follow along on our PowerPoint for our discussion. So what is the purpose of having a license law? I asked this of the students in my post-license. I talk about this with them. Why do we have a license law? And we have a license law to protect the consumer. And then I say to them, and who are we protecting the consumer from? And the answer is us. The license law is specifically there to regulate the relationships between the licensees and the consumers. It has very little to do with any realtor or licensee to licensee activity. They're not there to protect us from each other. The license law is there to protect the consumer from anything we might do that brings harm to the consumer. So, what it says in the license law is that the managing broker is responsible for the supervision of any licensee that they sponsor. So what specifically does that mean? And I think preparing our new brokers for what level of supervision is required by the managing brokers is an important concept. One of the things that I do in my 15-hour interactive pre-licensing course that I do is I walk them through how to interview at a real estate brokerage company so that they don't go in and go to work for the very first person that they have talked to, because they need to interview the companies just like they would do a job interview. It's not just the managing broker interviewing them to see if they want them, but the agent should be interviewing the brokerage company as well. So you might want to talk to them a little bit about how to go about doing that.